welcome to the deep dive. Today we're cracking open something that affects almost everyone, but maybe doesn't get talked about enough: local property rates.
That's right.
Specifically, we're digging into the rule book, the Local Government Municipal Property Rates Act, Act 6 of 2004.
That's the one. And it's, been updated, consolidated up to 2015, so that's the version we're looking at. It really governs how cities fund themselves at a basic level.
It seems like just a finance law on the surface.
Well, yes and no. If you actually read the preamble, the Act's opening statement, it's clear there's more going on. It's about giving municipalities a sufficient and buoyant source of revenue, sure.
Okay, funding. Makes sense.
But critically, it links that funding directly to fulfilling their constitutional developmental duties. And it specifically calls out the need to address, quote, historical imbalances from past discriminatory laws.
Ah, okay. So it's finance, but it's also got this layer of social engineering or maybe redress built right in. We're not just talking tax collection here.
Exactly. It's using the tax system itself as a tool for broader social goals.
So our mission today is to kind of unpack how this works in practice.
Precisely. We need to look at the fairness policies municipalities have to follow, how they figure out the value of every property, who gets a break, either completely excluded or getting some relief, and importantly, what you can do if you think the valuation is wrong.
Right. Let's start at the beginning then. Municipalities can levy rates, but they don't have unlimited power, do they?
Not at all. It's tightly controlled. First by the Constitution, then by this specific act, and then, really importantly, by the municipality's own rates policy, which they have to formally adopt.
And that policy isn't just administrative. It has teeth.
Oh, absolutely. Section 3 is very clear. The policy must promote local, social, and economic development. It must ensure everyone liable for rates is treated equitably. And crucially, it has to consider the impact of rates on the poor.
So national goals get translated into local rules through that policy.
That's the idea.
What's fascinating is the process for creating that policy. It seems very public.
It has to be. The Act mandates community participation. Before they adopt or even amend the rates policy, they have to put the draft out there physically in their offices, on their website, make it conspicuous.
And invite comments?
Yes, advertise it publicly and give people at least 30 days to submit comments. That window, that 30 days, is really the key moment for community input on how the city funds itself.
Okay, so the policy is set. How does the municipality actually apply different rates? Because obviously a factory isn't rated the same as a small house.
Right. That's where differential rates come in. Section 8 deals with this. They have to set different rates based on categories of property.
Categories based on what?
It can be the property's use, what it's actually used for day to day, or it could be the permitted use according to zoning laws, or sometimes a mix of both.
And are there standard categories?
The Act lists mandatory ones municipalities generally have to consider: residential, industrial, business or commercial, agricultural, mining properties, and properties used for public service purposes.
What if a property is mixed use, say a farm that also runs a small shop?
Good question. Section 9 covers that. The municipality can either assign it to the category of its dominant use, or if it's feasible, they can actually apportion the property's market value between the different uses.
So split the value.
Exactly. Say 80% of the value is agricultural, 20% is commercial. Then they apply the relevant rate for each category to that portion of the value. It helps align the rates with the economic activity.
But couldn't a municipality, say, create really specific categories to unfairly target certain types of properties or owners?
The Act tries to prevent that. Section 19 puts limits on differentiation. It explicitly says differentiation can't result in unreasonable discrimination. And importantly, you generally can't levy different rates on residential properties just because they're in different areas, for instance. Unless it's for specific legally allowed reasons, like phasing in rates on new properties or maybe special rating areas, or dealing with things like informal settlements. But the default is equal treatment for similar residential properties.
Okay, so the rate, the percentage is applied to the property's value. That brings us to the big one: valuation. How is the market value determined for every single plot of land?
Yeah, this is central. It all hinges on the general valuation process covered in Chapter 4. Municipalities have to conduct these comprehensive valuations regularly.
Oh, regularly.
Usually, the resulting valuation roll is valid for 5 financial years for a local municipality, or 4 years for a metropolitan one.
Can they delay it?
Only with permission. The provincial MEC for local government can grant an extension, but usually only for a year or two, and there have to be exceptional circumstances.
It sounds like a massive undertaking, valuing an entire city. Who actually does this work? Who's responsible?
That responsibility falls on the municipal valuer. This person is designated by the municipality.
Is it a council employee? Or can they hire someone?
It can be either an official within the municipality, or they can contract a private company. But the key thing under Section 39 is that whoever does it must be a registered professional valuer according to the Property Valuers Profession Act. The qualification is non-negotiable.
Okay, so a qualified valuer, what method do they use? How do they land on that market value figure?
The Act, in Section 46, defines market value in the classic sense. The price a property would likely sell for on the valuation date, assuming an open market transaction between a willing buyer and a willing seller.
The standard definition.
Yeah.
But how do they arrive at that number for potentially hundreds of thousands of properties? Do they visit every house?
Well, that's where it gets interesting and sometimes controversial. Section 45 makes physical inspection optional. Valuers are explicitly allowed to use modern techniques, including what the Act calls computer-assisted mass appraisal systems, or techniques. CAMA for short.
So algorithms and databases play a huge role now.
A massive role. For many property owners, the value is determined largely by these systems, analyzing sales data, property characteristics, location factors, and so on.
Which means the quality and transparency of that underlying data become absolutely critical if the computer model gets it wrong.
Exactly. It's efficient for valuing on a large scale, probably the only way to do it regularly, but it demands really strong oversight and quality control of the data and the models. The Act also specifies certain things to include or exclude.
Like what?
For instance, when valuing farmland, you have to disregard the value of any crops growing there or timber plantations. But on the other hand, things permanently attached to a building that are essential for its use, like lifts, air conditioning systems, escalators, those are generally included in the property's value. They're not seen as separate equipment.
That's a really important distinction. Okay, so the valuation is done, the rate is set. Let's talk practicalities. Who actually gets the rates bill?
The primary liability under Section 24 falls on the owner of the property.
What about places like apartment blocks, sectional title schemes?
In those cases, Section 10 is clear. The rate is levied on each individual sectional title unit, not on the body corporate for the whole building. Each owner gets their own bill based on their unit's value.
And if the owner just doesn't pay, what power does the municipality have to recover the debt? Can they go after tenants?
They can, but with strict limits. Section 28 allows recovery from a tenant or occupier, but only up to the amount of rent or other money that person actually owes to the owner at that time.
So the tenant doesn't end up paying the owner's debt out of their own pocket.
Precisely. The municipality can't claim more than what the tenant owes the landlord anyway. Similar limits apply if they try to recover from an agent managing the property. They can only get funds the agent holds for the owner. It protects third parties.
Right. Now, there's often confusion between properties that are completely excluded from rates and owners who might get some kind of discount or relief. Can we clarify that?
Yes, that's crucial. There are compulsory exclusions under Section 17. These are things the municipality may not legally rate. It's not their choice.
Like a line drawn by the national law.
Exactly. The most common example is the first R15,000 of the market value of all residential properties. That amount is automatically excluded from rating. Everyone gets that benefit.
And that R15,000 can change.
Only if the minister responsible for local government adjusts it nationally, usually for inflation.
What other kinds of properties are mandatorily excluded?
Big ones include most public service infrastructure, like roads, water pipes, sewers, power lines. Those are generally not rated at all. Also, property owned by a land reform beneficiary is excluded for the first 10 years after they receive it, unless they sell it sooner.
And religious properties?
Yes, properties used primarily as a place of public worship, including the official residence usually provided for the minister or equivalent, are also excluded under Section 17.
Okay, so those are the non-negotiables. What are the other kind of relief, the discounts?
That's where exemptions, reductions, and rebates come in under Section 15. These are voluntary measures a municipality can choose to offer through its rates policy.
Based on what?
Based on criteria they set for specific categories of owners. Common examples are relief for indigent owners, maybe owners relying solely on pensions or social grants, perhaps owners whose properties were damaged in a disaster.
So this is where the municipality has discretion to provide a safety net.
Exactly. It allows for local circumstances and social policies, but they can't just do it secretly. They have to report publicly each year on how much revenue they gave up through these exemptions, reductions, and rebates. Transparency again.
That makes sense. Ensures a basic floor protection nationally, but allows local flexibility. Okay, final big area. What if you, as a property owner, get your valuation notice and you think it's just plain wrong? What's the recourse?
The Act sets up a clear, structured process for challenging valuations. It's mainly in Chapters 6 and 7. First, you have the right to inspect the public valuation roll.
Check your property, maybe check your neighbors.
You can inspect the whole roll. Then, within a specific advertised period, you can lodge a formal objection against the valuation of your specific property. You have to state your reasons.
Who handles that objection initially?
It goes to the municipal valuer, the same person or entity that did the valuation in the first place. They review the objection and make a decision.
Isn't there a potential conflict there? The valuer reviewing their own work? What ensures fairness?
There's a key safeguard. Section 52. If the municipal valuer, after considering an objection, decides to adjust a property's valuation either up or down by more than 10%, that decision must automatically go for compulsory review by the Valuation Appeal Board.
So significant changes can't just be made internally without oversight.
Correct. It prevents the valuer from making large, potentially biased adjustments under the radar.
Tell us about these valuation appeal boards. Who sits on them?
They are independent bodies established by the Provincial MEC. Section 58 details their composition. The chairperson must have legal qualifications and experience. Critically, the board must also include members with property valuation expertise, at least one registered professional valuer. They bring both legal and technical knowledge.
So they provide an expert independent review.
Yes, they're the final administrative step in the appeal process.
Now here's the really crucial bit for anyone thinking of objecting, right? Does lodging an objection mean you can stop paying your rates?
Absolutely not. This is vital. Section 50, subsection 6 is explicit. Lodging an objection, or even taking it further to the appeal board, does not defer your liability to pay the rates based on the original valuation.
You have to pay now, argue later.
Precisely. You must keep paying the rates as billed. If your objection or appeal is eventually successful, the municipality has to make the necessary adjustments retroactively. They'll either credit your account or refund you, usually with interest. If the value goes up, you'll owe the difference, again with interest.
And trying to mislead the process is a bad idea.
A very bad idea.
Yeah.
The Act in Section 86 lists offenses. Things like willfully providing false information in an objection or a valuer acting with gross negligence. These can lead to serious penalties, including fines or even imprisonment for up to 2 years.
Okay, so pulling all this together, what's the big picture for someone trying to understand this act?
Well, I think you see it's quite a sophisticated piece of legislation. It's designed to give municipalities a strong, reliable income stream, which they absolutely need.
But it's not a blank check.
Not at all. That power is constantly balanced against principles of fairness, equity, the need for historical redress we talked about, and running through it all, mandatory public participation and transparency. It sets national standards while allowing local implementation.
And there's ongoing oversight to make sure it works.
Yes, Chapters 9 and 10 require extensive monitoring and reporting, both provincially and nationally. They even have to do studies comparing valuation accuracy against actual property sales prices, what's called ratio studies, to check if the system is working consistently. It needs constant vigilance.
Which leads us to our final provocative thought for you, the listener. The Act, in Section 21, mandates a gradual phasing in of rates over several years for certain types of property when they first become rateable, or for things like former land reform properties. This is clearly intended to cushion the financial blow and promote fairness.
A transitional measure.
But think about the challenge this poses for municipal budgeting. How can a municipality effectively plan for long-term financial stability and service delivery when critical revenue sources like potentially valuable public service infrastructure or large tracts of land are subject to these legally required multi-year phase-ins or exclusions? Is there a fundamental tension between the Act's admirable goals of equity and redress and the practical immediate pressure on municipalities to deliver services funded by a predictable revenue stream?